over to our distinguished panel. Thank you.
We were kind of talking about how we frame the presentation. What do we call it? Is it demystifying financing? And look, the goal today is to take out the esoteric, be concrete, and be specific. We designed the panel to hear from a funder, a funded client, and then funded outside counsel. So you'll see the various different perspectives. So it'll be less about trying to sell you on an idea, but really walk you through some real life tips and things to be thinking about as you are making a decision on how you want to approach a funded case, or even a case you may not know would be a good candidate for funding. So with that, we've kind of broken the presentation into really 3 big categories. We'll do our intros, which we kind of, I'm not sure what's left on that. That was great. And we'll talk about an overview of litigation funding generally, kind of what is it and what it's not. We'll break down what I think my favorite part is the economics, the business considerations for a funded case. And then we'll talk, and this is where you'll get your CLE credit on the legal considerations, and particularly around privilege and work product and confidentiality. So with that, geez, guys, is there anything we didn't say on the introductions you want to add on?
Why don't I just give a little bit more background and intro on the industry itself and how it's grown in the last decade. So litigation funding started in Australia in the 1990s. And then it migrated up to the UK in the 2000s, and then it hit the United States right around 2009, 2010. The funding company that I work for, Longford Capital, is one of the pioneers in the US, and it was formed in 2012. And if you just see how much growth we have had, it kind of indicates how much growth the industry has experienced as well. So in 2012, Longford's first fund was $56 million. And then in 2017, we raised our second fund, that was $500 million. And then in 2021, we closed our third fund for roughly $700 million. So the industry's exploding. It's only been around in the US for about 12 years, and we expect it to continue greatly in the future.
So let's get right into funding. John, what is it?
So in a nutshell, and I could go back again with a little history, litigation funding started when, really for like a single funded case, you have, let's say, Dan here has a company, and he wants to sue another company. We're talking about commercial litigation funding, not consumer, not personal injury. So pure commercial litigation, business-to-business litigation. So Dan has his company. He wants to sue this other company. It was either a breach of contract or they're infringing patents. Whatever it is, there's a harm done to Dan's company. And he gets a budget from Artouche and Clay Falls at K&L Gates because they're some of the best in the business in litigating cases, and Dan wants the best. So he gets this budget, and the budget's $5 million from soup to nuts to bring the case and execute the strategy against the defendant. And Dan doesn't want to spend the $5 million. He may not have the $5 million readily available, or he may want to put it to use for other reasons. So that's where we come in, and we fund the attorney's fees and out-of-pocket expenses so that Dan's company doesn't have to come out of pocket at all. We're the ones who are going to take all the financial risk, and in relation to that, there's going to be a reward for that. It's not a loan, because if Dan's case loses, if for some reason Clay and Artouche don't come through with a victory and the case is lost, we don't get paid anything. So Dan doesn't owe us a dime if the case loses. And we only get paid out of the recoveries from the case. So it's an investment, it's not a loan, and that's why there's no usury issues involved with the returns that we get. There's also a growth area in litigation funding now where we call it monetization, monetizing the claim. So let's say Dan has a case that he really likes and may even have a final verdict and it's on appeal, and he likes his arrangement with Artouche and Clay, but he wants to take money off the table. So instead of funding the expenses and the out-of-pocket costs, we'll pay Dan directly a partial portion of what we value the total claim to be, just so he could take money off the table. The CEO and the CFO and the GC get to show a victory in the case no matter what else happens. And then Dan and the law firm will continue to prosecute it, and then we'll still get our recoveries from the proceeds that are eventually recouped down the road. That, in a nutshell, is litigation funding.
Yeah, I think that kind of bodes well into one, I think, thing we've seen a lot as a common misperception is who controls a funded case. There's you're taking on an investor, you're taking on an experienced investor who's familiar with the claims, and a lot of our clients are like, geez, I don't want to give up that level of control, and that's not only not the case in practice, but every contract I've ever seen with the funder doesn't have, it's very specific on who's controlling it. It's not the funder. Dan, I'm not sure if that's been your experience when you've had two funded cases now.
Yeah, that's absolutely been my experience. There has never been any issue or confusion over who controls the litigation. It has been my decision in coordination with my outside counsel, and I've never felt pressure from a funder to do any one particular thing, one way or the other. Now, that being said, just because the funder isn't in control, I would encourage any in-house counsel who are working in a funded case to lean on their funders as a resource. Many of the funders are staffed by professionals who have very impressive legal careers before they moved into funding. They have a lot to offer you. Also, in their position as a funder, they are familiar with districts that you might not be familiar for a federal court case, with judges, with litigants. They may just know some scuttlebutt around the industry that you don't know. So I would encourage people to lean on that. One particular anecdote that was relatively a minor issue, but I had a case where the judge ordered us to come to an agreement on a mediator, and we were at an impasse to say the least, and I most certainly did not want to have my outside counsel stand up in front of that judge and say we couldn't agree on a mediator. I mentioned this in passing to a funder, and they were like, oh, hey, we had one of our cases, they used this guy, really, really tough, but really, really fair, and he made progress we never thought possible. Threw that over to the other side, they were like, yeah, we like him. So you just never know how they can help you. So even though they aren't in control, I think it's helpful to lean on them.
And from the funder's perspective, we specifically put in the deal documents that we will not control the litigation, settlement discussions, or anything involving the law firm who's handling the case. There's an additional reason why that's done, which is we don't want standing to become an issue where we are somehow interpreted as being the real claimant involved in the litigation, which would then open up all this discovery, which we'll get into down the road, which is usually protected. And so we're very careful to make sure that the documents and our behavior doesn't cross the line.
So I think the takeaway from our perspective is the client doesn't want it and the funder doesn't want it. They want to keep this separation of control so that you maintain your fiduciary relationship. The lawyer maintains a fiduciary relationship with the client. Client maintains the control of the litigation, when to settle, what decisions to make, how to make them, those kind of things.
One other practical point on that, and that is, again, from our perspective, we put in a lot of work in coming up, and we customize it for each case, but then we come up with the economics, who's going to get what, and we'll get into that in a little bit. But once the deal terms are signed and everything's agreed to, we then let the law firm and the claim owner go and execute on the strategy, because everybody then knows who's getting what when it resolves.
So, John, we talked a little bit about the growth, the trends. Let's talk about the specific types of claims you're seeing that are getting funded.
So it's really any type of commercial case, commercial dispute we would be interested in funding. We typically, for us, because we're one of the largest funders, we want to see a damage model that supports at least $25 million in damages. Not that it has to settle for that, but we typically want to fund a couple $1,000,000 at least for each case. And so if there's at least 25 million in a damage model to support it, then there's a big enough pie to get us back what we funded plus our return, and then get the law firm a success fee and get the claim owner the lion's share of the recoveries. We see a lot of patent infringement cases in particular because it's so easy to meet the damage threshold for us. Damages are usually not even an issue in most of the patent infringement cases. But then any commercial case, breach of contract, business fraud, bankruptcy-related cases because the trustee doesn't have funding, so they're looking for funding vehicles to prosecute third-party claims in the bankruptcy context. A lot of antitrust in the food and healthcare industries involving price fixing. We see a lot of that too. And international arbitration's always been hot.
And what about you? You've now funded a couple. What sort of claims did you think were right for this model?
You know, my practice really solely focused on IP related claims, and as John said, it's kind of a perfect fit for it. These cases are extremely expensive to bear. In one situation, I had parallel litigation in front of the International Trade Commission and in federal district court, and for a small company, it just would not have been feasible to bring. And also, you know, it's particularly easy to get those damages up there, especially if it's somebody infringing on, you know, a technology that you find in a smartphone or something of that nature.
Yep, that's pretty consistent with what we're seeing as well. A lot of our clients across industry, I put the slide up to talk about the types of clients that are out there using, the types of businesses that are out there using funding, and along the same lines of the patent really being an ideal case, although there's so many different ones too. But universities are great. They come up with the technology, they're the inventors, but they don't want to throw a big budget behind asserting their patents. That's been a good trend and a growing trend. We've been seeing a lot on startups and vendors, people who don't have the wherewithal to go after the Fortune 10s and the Fortune 20s and pay millions of dollars over 5, 6, 7 years to assert their rights. So it's really brought a lot of liquidity to the market where the little guy, so to speak, was otherwise not in the game. So this has been a nice, for these models, particularly in IP, but a nice way to sort of bring that out to bear.
Well, I'll just say that, and it's up there, but again, it started back when it was small company going up against the giant company and to kind of level the playing field. But as it has evolved, certainly law firms who are very in tune with our industry have really taken to it, and they present to us groups of cases for different clients, and we call it a law firm portfolio arrangement. So law firms, both huge and small and specialized, have really been interested in taking advantage of our capital. But even the largest Fortune 50 type size companies who have a plaintiff side docket to their business model have also been extremely interested in our capital.
Yeah, that's a good point. And we put this bullet at the end about the traditionally defense-oriented firms. Firms like ours, Kane Gates, we're mostly on the defendant side, but we've become very active. Our clients who've got claims who may otherwise not want to come to us to assert them, now it opens that opportunity. So we're seeing a lot more. The big firms are getting more into the game. So it's absolutely a good tool to have on those particular clients who may not otherwise want to do something with their claim or even use their preferred counsel to do something with that claim. Okay, Dan, I think people want to know the why. I mean, take us through, the business considerations, why you would do this.
Well, I think there are just so many reasons why you might want to use litigation funding. And to build on what John said, that can be from a struggling startup that's cash flow negative, a small to medium enterprise, or even a Fortune 50. There's a lot of reasons why this makes sense. When we talk about risk reduction, I think the number one for me is the budget predictability issue. Bringing a complex plaintiff side litigation can be tremendously expensive, especially within an IP case or other complex torts. And not only is it expensive, you have a lot of unpredictability on when you're going to be spending money, how long this might take. Is somebody going to randomly, win a stay, a year in, and you got to wait 2 years. And I think if there's one thing that upper management does not like from their legal department is spending more money than they have to and spending that in an unpredictable manner. So litigation funding can eliminate those objections. If you think you've got a valid case, you can go up the chain. Your GC can talk to the CEO and basically explain, look, there's no money out of pocket. We're not asking to increase the legal spend by any meaningful amount over the next 5 years. And in return, we're going to get a recovery. And so that can make a case a lot more palatable in ways that it wasn't before litigation funding was wildly available. And then I would also sit there and say, even if the CEO says, you know what, I don't mind spending all this money bringing a case, is that really the best use of capital for the organization? That money might be better spent on organizations, growth efforts, M&A. So there's a real opportunity cost deploying that capital on legal fees and, again, litigation funding can alleviate those concerns. But for me, I think the biggest reason and the one that resonates the most strongly with me is the greater access to justice. Prior to litigation funding, I think there were many small businesses who had suffered various torts, and they really just had very limited recourse because they couldn't afford a high-quality law firm to represent them and pursue the case to the fullest extent. I would say, in my opinion, over the past 5 to 10 years, finding quality law firms that want to work on a straight contingency basis has become very, very difficult to maybe almost downright impossible. And so again, here litigation finance allows some of those cash-challenged entities to go to court and have their fair day in court and recover what they're owed.
Yeah, real life example. We had a middle market privately held company entertaining idea of a big dispute on the horizon, and they didn't want to incur the risk, they didn't want to incur the fees. They were thinking about an exit, and so the effect on EBITDA was a big deal. And this was an opportunity. Hey, what do you think about this? And all of a sudden, they ended up getting it resolved without having to use funding. But that was a big consideration that you could take this right off your expense ledger, and it's not there. Someone else is incurring it, and you get to upside when they have it, and none of the downside when they don't. So it's a good strategy for that model as well. All right, this is my favorite part. This is the business considerations of funding. I'm going to nerd out with you all for a little bit. The economics of a funded arrangement are just fascinating. There's no one model. This is a contract arrangement between company and funder, but you're starting to see things develop that are kind of becoming the norm, although we see some pretty weird stuff out there too. But generally speaking, John, can you take us through, maybe Dan, you could share your experience and kind of how these things are structured?
So let's go back to the example where Dan's company had the $5 million budget and K&L Gates is leading the charge. What we do is we make sure there's alignment of interests with the funder, us, and the law firm, and we make sure we're all rowing in the same direction. So how do we do it? We turn to the law firm and we say, we have your budget and we want you to give us a 50% discount off the fees. So that $5 million, let's just say the $5 million was all fees, because we're going to fund 100% of the out-of-pocket expenses because we don't want anybody to be out of pocket. But on the fee budget, we want the law firm to have serious, significant skin in the game so they're rowing in the same direction. So we get a 50% discount, and in return for that, the law firm gets a success fee. And the whole point is that the success fee should make up way more than just the 50% discount. So the law firm makes out, we make out, and then the claim owner also makes out because everybody's going after the end result. That's essential to successful litigation funding arrangements. We will get, and we want to fund the strongest cases. So we turn down more than 90% of all opportunities presented to us. The law firm partners and clients that we have a history with, they know what we're looking for. So we accept a lot more of a higher percentage of those opportunities because they have vetted them already and they already know what we're looking for. But because we want to fund the best, most meritorious cases, and we have enough opportunities to do so, we want the law firm to present it to us and actually embrace this 50% discount and be excited to give the discount on the front end. There are lots of variation with how law firms approach it. Some are a bit old school still and don't have a lot of experience with litigation funding, and they'll say, oh, our management committee won't accept that, and we'll do a 30% discount or a 25% discount. And then we kind of, it's our option whether to fund or not, which we won't fund in those types of situations, and we'll let them go on to other options. But that alignment's critical, and through history has worked out the best for all involved.
Dan, what kind of structures have you seen, either in the deals you've done or the ones you sort of considered?
Yeah, so a variety of different structures. There was a funder I was speaking with about putting a series of cases, actually to a point John raised earlier, putting it in their law firm portfolio pool. And that would have allowed them, from my client's perspective, to look like a straight contingency deal, even though the finances between the firm and the funder were, opaque to me. It didn't really matter. I've seen cases sort of where there is a budget set, at the outset, the firm works at a discount, 50% is common. And then, as money comes in, it's sort of allocated in tranches. I've seen a funder that wanted to basically pay a fixed amount per stage of the case, and you had to complete that stage of the case before you got a lump sum payment. You can work them a lot of different ways, but I do share John's enthusiasm for making sure there's an alignment of incentives. It sort of ties back into that control issue. If everybody's incentives are aligned, they're really, you shouldn't have to worry about control anyway because it's crystal clear, but you're not worrying what other people are thinking, because when the incentives are aligned, everybody wins through the same process. And, I think I might have a concern as a client if a firm, wanted the majority of their fees up front. I'd ask myself, well, look, are you just looking for a guaranteed amount that you're going to be able to bill? I'd rather you being willing to risk it, having faith and confidence that the returns on the upside are going to make it worth your while.
And then to put a little more meat on the bone in terms of how the distributions typically work, just generally speaking. So again, if the case loses, the claim owner company owes us nothing. As a result, if there are proceeds that come through, the funder always gets what we funded off the top, plus a preferred return. And then the rest of the waterfall distribution is basically customized based on the particulars of the case. But roughly speaking, we'll get our return either based on how the time duration, how long it took to resolve. So the longer our capital is used, the more return we'll get. The shorter resolution, the less we'll get. Or it'll be just a sharing of percentages on the proceeds. And then, of course, the law firm needs to get their agreed percentage as well to make up for the discount.
So I wasn't going to do this, but I can't help myself. You might lose a CLE credit or ethics credit on this, but when I had a conversation with John some time ago and we're talking about fees, and he looks over and goes, Artush, we want to see skin. And I was like, excuse me? You want to see? What did you need from me? He's like, no. Cut your fees in half and take a contingency. That I can do. We're no problem. Jeez, I was getting nervous. Didn't know I was going to tell my wife. Anyway, so this segues nicely into, I think, making the decision as to your funder, as to your outside counsel. These are important considerations. It's not something you take off the shelf, and not everyone's suited for those roles. Dan, you had to do both. Take us a little bit through the funding decision.
There are so many factors to consider. I think it's sort of obvious most people are going to start with what are the economic terms. And there's perhaps could be a tendency to just purely shop economic terms as if that's the most significant driver of the deal. I would strongly discourage that mentality. There's far more to this than economic terms. Considerations that are important besides the economic terms are, one, does the funder actually have capital? there are some funders out there who maybe don't actually have capital to deploy at that particular moment. They need to go get that capital and get it approved. Whereas other funders, have a war chest that it's ready to go as soon as they deem it worthwhile. Reputation and experience are key. I would be very nervous about going with a new funder who doesn't have a track record of funding these types of cases. Each type of case is unique. Funded cases are unique. There's a possibility of difficulties arising. An experienced funder will have seen it before. They're not going to worry. And that makes your life easier as in-house counsel. I think speed is an underrated factor. Different funders have different processes. They take longer to get through diligence. You may be probably tied up in exclusivity during the diligence process. So a funder who's able to get you a decision in a timely manner, is going to be very helpful to you in case they pass. You don't want to wait to bring this claim. And I think, overall, you should remember this is likely to be a years-long relationship. So finding a good fit, making sure you're philosophically aligned, I think is more important than somebody giving you an extra 2 points on the back end. So obviously economic terms are important. Don't let that control your decision. I would also say, building on something John mentioned earlier, there are more and more options for funding. So as in-house counsel, you're in a better position to find a deal that would work for you. Artush, anything to add on that?
It's funny you say, so the reputation matters, the access to capital very much matters. We've heard, I'm on a committee in the firm, and there's a horror story of a client who got funding and the funder actually didn't have it, or they ran out 2 months in. What do you do with that? I mean, now I have a breach of contract claim against the fund. It's a horrible position to be in. You're in a funded litigation and the funder is not funding. And so it puts everyone in a very difficult position. So the access to capital, the reputation, just get one less thing of drama in your life and check that box. You're going to get your money and you're going to move on. So that's an easy call. And that's sort of been my experience, is stick with the ones you know. It seems like a decade ago or 20 years ago, even, there's a bunch of folks that got involved in buying bankruptcy claims. And now they're kind of getting into funding, and there's hedge funds now, kind of a portion of their portfolio is getting into litigation funding. And it's getting a little Wild Westy. And not all those people have lawyers, and not all those people understand the intricacies of these legal issues. And that's where you have those problems with, we're going to talk about sort of privilege and confidentiality and all those. There's a lot of other implications of just kind of going with some Joe off the street. So I think reputation is a huge factor. And I'd give up a few points to your comment to go with someone you know and have one less thing to think about. And I think that then you got your funder. How do you choose outside counsel? Of course, Kano Gates is so great, but I mean, I'm sure there's other options out there. I'm told. So Dan, walk us through the decision. You've hired outside, and John, I'm sure people come to you and ask you for advice. Where do you go with it? So kind of help us understand what the folks here should do.
Sure. I'm guessing that most, if not all of you, have experience hiring outside counsel. Many of those factors and considerations will apply here. In a lot of ways, there's certainly some quite a bit of overlap, but at the same time, you may not be able to go with your preferred outside counsel. In my experience, I was trying to go with a firm that I really wanted to use, but their management committee was just very old school. They had never done a funded case before, and they just weren't seeing how that could work. And they really wanted me to try and figure out a way to work with them. I sort of came down to the conclusion that, if you have to work that hard to convince a firm to take a funded case and work a funded case, I think you're likely buying yourself some headaches down the road. I really would strongly encourage you to find a firm that is familiar with funded deals. Ideally, the firm you like would have experience with the funder you like. I don't think that's a hard and fast rule, but it certainly makes life easier. It's easier to feel like everybody's expectations and goals are aligned, and I think that's just going to make your life easier. If something on the case goes a little sideways, having some familiarity and trust goes a long way. I don't know, John, any thoughts on outside counsel?
We often are presented opportunities that already have the law firm involved and engaged, but we also receive lots of opportunities where that's not the case, where it's directly from the claim owner who doesn't have outside counsel in place, or who has a handful of law firms they're considering and they want our opinion on those. So what we do in those cases is we will refer them to some of our great trusted law firm partners that we've worked with a lot in the past, who we have a ton of confidence, who we know are going to embrace our funding structures and do a great job.
Yep. From my perspective, the last bullet point has been a differentiator, and you'll find, to the point earlier about some firms just aren't there yet. And there's a lot of firms that just are not there yet. They're not willing to do the price, the fee reductions, the contingency component, or it's going to be 3 months into some committee before they get back to you. So you're going to find that a lot of your normal usual suspects are kind of eliminated right off the bat, just because they haven't quite figured it out. This is where the market's going, and you have to be flexible. So the flexible fee arrangement is just absolutely critical to obviously how this is all going to come together. All right. So here's the kind of boring part. We're going to try to hit it because you need your ethics credits. But it's really important. It's going to be granular, but it's really important. This is the stuff that the lawyers in the room, we've kind of talked about the business stuff and the economics and kind of zooming out, but this is where you're going to add a lot of value too, and making sure you don't waive a privilege, making sure your communications with the funder are done in a way that don't bite you in a year or two down the road when you're litigating the claim. So this is where care and being deliberate matters a lot. So generally speaking, I think, John, it'd be helpful if you just kind of walk us through start with the diligence period. It's not unlike buying the commercial real estate. You do diligence, right? So what's that look like?
All right. So we at Longford have a 2-phase due diligence process. Not all funders do, but we do. Here's how it works. So we want a case that we call it that's fully baked, that's been already vetted with the law firm. The law firm believes in it. So the company claim owner, they believe in their own case. They get their legal counsel to look at it. They believe in the case as well, and they're willing to have skin in the game. So now it's presented to us. We have several lawyers in-house. I'm one of them who've had lots of commercial litigation experience. So we review it internally. We look at the key information that a law firm would look at, whether they were going to take it on a full contingency fee basis. So what's the strength of the liability? What's support for it? What are going to be the main defenses? What's the damage theory? Venue issues? Everything you would think would go into putting money into a case. If we really like it at that point, we'll do a letter of intent that sort of highlights what the key economic terms and other provisions that would go into a funding agreement, but it's at a letter of intent stage because it's always contingent on our second phase of due diligence. And that is, we always, and I mean always, hire an outside law firm on our behalf to do an independent case assessment for us. Longford Capital is the client. And they'll look at the same information we did, and the outside law firm will kind of give a rating system that we provide to them. And if it passes the green lights with that, then we go to a funding arrangement at that point. Other funders don't necessarily do the 2-phase. They'll try to do a term sheet up front to kind of lock in exclusivity. Then they'll go through their due diligence period. That never made any sense to me personally, by the way, because why are we bidding on something that we don't even know yet on what's the overall strengths and issues involved in the case? But that's how we do it, and it seems to work out pretty well in sequence.
And now, Dan, once diligence is done, you got your funder, it's now funded. You're having some level of communication for the rest of the case with the funder, right?
Absolutely. Every funding agreement I've seen has a provision where the claim holder is required to provide the funder with updates. The claim holder can do it directly. The claim holder could authorize outside counsel to do that. I would say at a high level, it is going to vary perhaps quite a bit by funder. Some really want to know much more frequently what's going on. Some are fine with a check-in once a quarter. It also obviously depends on your case status. If you're waiting 120 days to serve somebody through the Hague, your funder probably isn't too concerned about what's going on. In my opinion, the easiest way and the way I'd recommend updating your funder is just setting up a regular call or a Zoom. I don't like to put something like that in writing by any means for many reasons, but it's also just a nice way to kind of check in with your funder. And again, this is a long-term relationship, or in my opinion, it should be. So getting on the phone with your funder and just letting them know what's going on is a great way to maintain that relationship.
Practically speaking, we're kind of a people person outfit, and we talked about the due diligence process. So we start building a relationship both with the claim owner and the law firm as part of our due diligence as we're internally evaluating the case. And what typically happens is there's a great deal of mutual respect that goes back and forth between the law firm, for the most part, because that's who we're dealing with directly on the due diligence, and us internally. And then we get that law firm involved on our behalf, and then there's additional relationship and confidence being built. And we raise, or the law firm that we hire raises issues that actually enhance the campaign for that particular case. And the law firm leading the charge actually appreciates it. So by the time we do a funding agreement, we actually have built up a really strong relationship with the company and the law firm handling the case. So in terms of updates, as the case goes on, we could do it on video conferences, we could do it over breakfast, we could do it over a round of golf, we could do it over a scotch at night. It's however to get in face-to-face and actually enjoy the relationship as well as getting the case updates is how we operate.
And you can see how a lot of these issues, if you're thinking, geez, diligence on the case, they're going to want to know the merits, they want to know strengths and weaknesses. How do you protect your trade secrets, your confidentiality, your work product, your privileged communication? So all these things get implicated, not just in diligence, but then the updates throughout the case and keeping your funder involved. And you can get kind of lost in a morass if you kind of think too much about it. But the good news is it's not as bad as you think. It's much more easy to navigate than you'd probably suspect.
Artush, can I chime
Absolutely,
in
get in,
on
yeah.
one thing on the due diligence process? I would just say, as a claim holder, you might be nervous about sharing information that could be perceived as negative to your case. I think that's probably the worst possible thing that you can do because the funders tend to be sophisticated. Their diligence, outside counsel is going to be sophisticated. You can work through problems if you know what the problems are at the outset and figure how to deal with them. So trying to hide bad facts is a losing strategy.
And a winning strategy is actually identifying the weaknesses of the case and the defenses up front early into our conversations and actually having a strategy on how to deal with it. That really gets our attention very quickly.
So John, on that point, how do you ensure that you're not waiving some confidentiality or ruining the claim holder's confidential information?
So what we do, the very first thing we do is we get an NDA in place, and we have two different versions. One's an NDA directly with the claim owner, or we do an NDA directly with the law firm. Either works. We have it under Illinois law because there's a seminal case in Illinois called Miller versus Caterpillar, which is has extremely strong protections for information exchanged with funders based on work product, also not being relevant. We don't want attorney-client information. We don't ask for attorney-client information. We tell the law firm and the claim owner, don't send us attorney-client information. We could easily get around any particular issues through phone conferences, video conferences, and information that the law firm will exchange with us that haven't been exchanged as an attorney-client privilege communication.
A couple quick points. The first is this is why picking a sophisticated funder matters, because they don't want the trouble that you also don't want versus an unsophisticated funder who may be leading you astray or putting pressure on you to divulge more than you ought to divulge. And the second thing is the NDA. It's not only good practice for the funder, but it's got to be essential for the client. You'll find, as we kind of hit the next couple of slides, this is essential to maintain your work product. So to the extent you are sharing information, you need to make sure that you've kept it secret. You take on reasonable efforts to make sure the public does not become aware of it. And those become factors in weighing whether you waive work product protections. Okay, we got a slide on privilege. I mean, we're not going to kind of waste a lot of time on it. I think the point is the privilege is it's attorney-client. It's about legal. So talking business issues doesn't, get you the privilege protection. Talking to a third party doesn't, you likely waive your privilege. So talking to a funder and sharing your privilege information, I mean, there's no Supreme Court case on it yet that I know of, but the cases uniformly are pretty clear. It's a third party. Most of the times it's a non-legal issue, it's a business issue, and therefore there's no privilege or you've waived it. So don't do it. Work product. We talked to, and John, I'd love to hear your perspective on it. I mean, the idea is you've got your work product, the client's work product, and you have the attorney's core work product, their mental impressions, their view of the case, their analysis. And a lot of that becomes very important, and you've got to be able to share your candid views on what you think is out there with your funder. The funder is going to be taking that information in as part of its diligence. So that's, John, if you give us some insight on how you go and get that information and protect it.
Yeah, and here's a great example. One of the first things we want to review in the case is a summary memo prepared by the law firm about the case opportunity. So this is not a memo from the law firm to the client, attorney-client privilege, and then they're sending it to us. This is a memo that the law firm prepares specifically for the interests of obtaining funding on behalf of the client. And so in that memo, we're going to get the law firm's candid perspectives on all the key issues, broken out by strengths, weaknesses, liability support, damage model, and the like. What's the strategy? What venue is it going to be brought in? Why is it going to be brought in that venue? And anything else you would think of in terms of like high-level key criteria. Now, that's work product, but it's protected. It's not attorney-client privilege. We have case law to support it, and we've never lost a subpoena for requests for information to be turned over to the other side.
Dan, I take it part of when you're on the client side is you've got to control a little bit of the chaos and people communicating with the funder and making sure you're not having some slippage. How do you do that?
Absolutely. It's a very serious issue and one that requires some attention. The easiest way to do it is make sure there's a single point of information flow. Not that that's the only person that can communicate, but one individual should be in the loop on every single communication so that they are able to see what's going in or out and being able to proactively let people know what can be sent, what can't be sent. Preferably, this should be somebody in your legal department, but you can get yourself in real trouble with one-off email conversations that you don't know about.
Yeah, I think the same is true for the law firm. I mean, we're on funded cases where not everyone on the team knows it's a funded case, and they don't need to know. Management needed to know when they approved the fee model, and that's it. So really focusing the communications and having defined parameters on who's talking to whom about what, that's going to really protect against kind of accidental, you don't want a casual conversation with a funder and they're playing around in golf and all of a sudden here's this view on this thing, like, well, why'd you do that? And that's not what you were supposed to do. So we control that from the firm, and the client should be controlling that from their perspective, including their business and finance folks who may be otherwise, very interested in seeing how the funding plays out. Okay, so the legal issues, we put it up here, it's a legal abyss, but it's kind of narrowing out. It's just not definitive yet. So if everybody wants to see 100% certainty, I want a Supreme Court case 9-0 ruling before I feel comfortable about it. But the cases kind of are shaping up pretty consistent. As I said, it's your privilege, whether you do it, whether you're trying to come up with an argument of did it extend to the funder or not, or you had a common interest, and maybe even got it memorialized in a common interest or a joint defense agreement. But pretty consistently, the courts are saying, I don't think so. No, that's waiver. That's a third party. Your privilege is not protected when you're communicating confidential communications, legal advice with the funder, right? I think you're hearing from John, and we got some cases here, and John, your case, the Caterpillar case is there. There's a lot of that gets shepherdized pretty strong, gets cited to a lot. It's building a lot of momentum. The idea being core work product and even work product more generally is protected pretty consistently. Not only for what the client's assessment of it was, but the communications with the funder. What's the funding agreement look like? People ask for that kind of thing from time to time. Dan, I'm not sure if you've seen that, if people have made funding the issue of the litigation.
I wouldn't say they've made it the issue of the litigation, but I think in every single funded case I had, there were various discovery requests seeking the agreement, seeking communications with the funder. And as I mentioned, these cases were basically all intellectual property, patent litigation cases. At the end of the day, the funding agreement and communications related thereto have nothing to do with infringement, validity, or the calculation of damages. And there was some bluster about, how they're going to file a motion to compel and you've got to turn this over. But I was in a forum that had a reputation, had already established this, that those types of communications and documents have no relevance. They're not going to be, the judge is not going to force you to produce them. So I think opposing counsel wisely realized that filing a frivolous motion to compel would only anger the judge, and it just wasn't worth the time. So in my experience, despite some bluster, it was a non-issue.
Yeah, same here. I've never seen a case cut off the rails because they really want to know, is it funded or not? Take discovery from the funder. I mean, I'm sure it's happened. I mean, John, maybe you've seen it, but it just doesn't seem like worthwhile investment of the opponent's time. It doesn't move the needle. And so it doesn't really come up. The one thing I'll note about work product is, and John noted earlier, it's pretty consistently upheld, but it's not necessarily established in every jurisdiction. So there's a Delaware case that kind of goes the other way. And so there's some places where you may see, so be thoughtful about that. Be thinking about where you can build your nexus. John's point earlier about rooting your NDA in Illinois law is a great takeaway. So finding ways to say, I know the law in this jurisdiction. How can I build my nexus to it so that if the court's doing a choice of law analysis, they're going to apply that law?
Yeah, let me comment on that Delaware case. But before I comment on the Delaware case, when litigation funding first started, it was like a big topic when defendants either found out that a case was being funded or suspected that it was being funded just because it was new and there was uncertainty involved and the defendants didn't really know what it was all about. So there would be a lot of discovery disputes earlier on. There's actually less and less discovery disputes lately because litigation funding is becoming so much more accepted. Every case that I've seen where work product wasn't upheld as a protection, there's usually unique facts and circumstances involved in that particular case that makes it a one-off. In that particular Acceleration Bay case, the plaintiff who was getting funded represented to the court that there weren't any materials to produce at the beginning of the discovery dispute. And then lo and behold, there were, and that set them off track. Also, there was no evidence that an NDA was even in place. So bad facts lead to bad holdings, but there's been Delaware cases that have upheld the work product doctrine as well.
Yeah, and that comes full circle on that NDA. It's critical. If you're going to have your work product, you've got to have that confidentiality agreement, and you've got to do the things that you're manifesting an intent to keep it otherwise a secret, and you're just sharing it with the people who need to know for that limited purpose of needing to know. All right, so this is the last slide, and we'll open up for some Q&A, and hopefully, maybe if we have time, we can get out a little earlier. But the kind of takeaways, guys, give us a few that you think are the folks in the audience can get a nugget or two out of this.
Yeah, I mean, I'll just jump in on the using professionals with funding experience. I mean, you've got a complex litigation ahead of you. You're just going to be so much happier if you've made your life easier at the outset by working with funders and firms who know exactly how this type of process works. This is not the time to take a risk on somebody new to the game. That's something I feel quite strongly about.
If you don't have a lot of experience with litigation funding, by all means, reach out to us early, as soon as you even think you may have an opportunity. I said before, we like to see a case fully baked. That's to actually undergo our serious due diligence, but oftentimes we do get approached early on when we help the companies navigate through and get to a structure and law firm placement and feeling good about the path forward, and then we'll loop back and get involved in a due diligence later. So by all means, reach out to us as early as possible.
Yeah, I think that one of the earlier slides talked about the types of claims and the types of companies that use funding. I think if you looked at that 15 years ago versus now, you'd be surprised of how ubiquitous it's becoming. So I think if we can kind of implant an idea in your head is it's more available than you think, and it could be a good option, and you don't have to have that home run case. It could be a thing you do as part of your ordinary course of business and managing your portfolio or your legal risk. And so there you go, guys. That's the presentation. Any questions from the audience?
Yeah, in my experience, it did. I think that there are a lot of traditional larger defendants who, prior to litigation funding, would know that plaintiffs didn't have a lot of money, or maybe they were working with a smaller firm that was on a pure contingency, and you could take the strategy of just work them to death. And they didn't have the bandwidth to have 15 attorneys on the deal. I don't know that I would necessarily recommend disclosing that you're funded early, and you may not want to do it at all, but it does change the nexus, because when you are a plaintiff and you're funded, the defendant can no longer say, I'm going to work you to death and try and get you to settle for pennies on the dollar.
Some defendants are a little concerned that if they think that the defense is really strong and it's not a good case, that it's going to spike up the settlement value, or it's just not going to settle and the company's going to take it all the way through trial regardless. But that's not the case, because we're getting updated. The law firm knows the case as well. The claim owner knows the case. And if it's not going well, the goal is to get as much as you can, even if the case is underwater.
Yeah, the one thing that I'll add to that, there's a psychological element to it, and I've seen funded, so the defendant who thinks, oh, geez, these guys have the wherewithal, they may approach the case differently. Sometimes our clients also, who may be more inclined to take a deal, are less inclined to take a deal because, hey, I'm funded and I'm going to see this thing to the end. So I think that's a balancing of trying to meet expectations and make funding the non-factor, right? But it comes up. Does that make sense?
It varies on jurisdiction and subject matter. So in the Northern District of California for class actions, it's a requirement that it be disclosed. Sometimes it's just the identity of the funder that gets disclosed. Sometimes it's making sure that the funder doesn't have control, so to do an in-camera inspection of the deal document, and it has that provision in it. Some, there's no disclosure whatsoever, which is the more common view right now in most jurisdictions, but it does vary. There was a question in the back.
Thanks. I was just going to ask real quick, with law firms obviously have to do a conflicts check. Do you do something similar when you're receiving cases?
Yeah, for sure. Nothing changes. On a conflicts check?
Yeah, but if when you're seeking funding.
Oh, in other words, are we adverse to the funder?
Yeah, so a funder could, I mean, if you've got multiple clients, multiple law firms you're working on, you could see a situation in which they represented both sides, or...
Yeah, I mean, when we do our internal, and I don't know the internal workings of how it's done, but absolutely we include them as a client-affiliated party because they're going to have an economic interest, right? There's some alignment there. But it's never, I haven't seen an instance where it's come up and we're like, we've been adverse, because we're probably not going to be working with that funder if there's an adverse relationship. More likely than not, one of us is going to be detracting the other from the opportunity, right? So it hasn't really come up that much at all. But was that a speech masquerading as a question, Dana?
That was the best I could come up with.
Great question. And so there is we call it a material adverse event provision that's in the funding agreement. That gets negotiated as to what constitutes that. What we typically do is reserve the right whether to fund an appeal, which kind of protects us then. So if we lose a motion to dismiss or a motion for summary judgment and the claim owner wants to continue with an appeal, we have certainly the right to fund it, but we also have the right not to fund the appeal based on the overall facts and circumstances and likelihood of success.
But it's all contractual, right? So if they have a contractual out, you'll see that this is all pretty bespoke stuff. So to John's point, you know exactly if and when certain things are happening. But normally they don't have I've never seen a situation where they had complete discretion just to turn the spigot off. Again, I talked about the funder that we didn't know very well that stopped funding a client. That was just because they lacked wherewithal, not because they breached the contract.
A dismissal of the claims is typically in the material adverse event, and you get your claims dismissed. we just have to take a look at it at that point. Say that again?
From the initial phone call from the law firm
yes.
to inking the deal, how long is that period?
Yeah, and so that's going to vary based on how developed the case is when it's presented to us. Oftentimes it's presented to us and it's not fully baked. It's not completely there for us to review. All the information hasn't been, and by the way, we have a secure data site where the law firm uploads all the information. But if it's all there and all the information we're looking for has been provided, it's usually a 2-week process internally to get through it and a 2 to 3 week process for the outside law firm to get through it. We have expedited that if the claim owner has certain deadlines, and we have really expedited it to meet those deadlines, even if it's a matter of to get everything done in a week, because we're just going to work overtime to get it done.
All right, we are out of time, but let me impart you with this. This is a great panel. I mean, of course, right? But a lot of knowledge here. And if you see folks in the hallway, pull them aside, get to know, talk to John, talk to Dan. Here's a client who's managed funded cases and went through the economic analysis and decisions. There's a guy who's sitting over $1 billion in funding arrangement. And then you manage a handful of outside counsel funded cases. So use us as resources, talk to us in the hallway, and we're happy to chat. Great.